Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. On this show, you're going to learn something new about the legal and policy issues involving competition, consumer protection, foreign investment, and privacy law. Whether you're a seasoned practitioner or just trying to get your bearing on some of today's biggest debates. Each episode is brought to you by one of the specialty committees within the section. Today's episode is produced by the Foreign Investment and National Security Committee. We're taking a deep dive into foreign investment in Canada. At the start of the new administration in the United States, President Trump abandoned long-standing trade agreements and replaced them with a tariff-centric trade policy. In March 2025, President Trump imposed 25% tariffs on Canada, his northern neighbor and one of his biggest trading partners. This kicked off a series of back-and-forth tariffs between the two countries. As a result of this uncertainty, Canadian Prime Minister Mark Carney has emphasized the importance of reducing Canada's reliance on the United States as a trading partner. During a trip to Beijing in January, he announced a new trade deal with Canada, slashing tariffs on Chinese-built electric vehicles in exchange for reduced export tariffs on Canadian exports like canola seed oil. Does this signal a permanent shift in the Canada-U.S. trade relationship? And does this represent a new opportunity for Chinese companies looking to do business with Canada? Here to discuss these issues with me today are my guests. Brian Facey is one of Canada's top antitrust and foreign investment lawyers and a key architect of Canada's top-ranked competition, antitrust, and foreign investment law group at Blake's, a leading Canadian law firm. Steve Verheul is a principal at GT & Company and the former chief trade negotiator of Canada. He was responsible for negotiating, well, I guess it depends upon how you see this, CUSMA or USMCA, depending upon your latitude, I guess, and the Canada-European Union trade agreements. Brian, Steve, welcome to the show.
Glad to be here.
Thank you very much, Anant.
Brian, just before this recording, China announced that it was going to block Meta's acquisition of Manus, a Chinese AI company that recently located in Singapore. And Prime Minister Mark Carney announced the creation of a sovereign wealth fund, the Strong Canada Fund, to finance major projects of national interest. Investment in and by Canada is clearly a red-hot issue right now. How should practitioners be thinking about the signals we're seeing from both of these countries?
First of all, thanks, Anant, and it's a pleasure to be here. Steve, very lucky to have your expertise on the topic. As Anant has mentioned, those two developments, very recent, highlight the importance of this area and just the real shift that's going on in the area globally within Canada, the U.S., and with our European trading partners, and also China and Middle Eastern sovereign wealth funds. Let's start at a high level, Steve. Yep. When Canada signals openness to broader global engagement, including potential trade and investment involving China, should practitioners interpret that as a major policy shift?
No, I wouldn't say so. I think that clearly Canada is focused on expanding our trade agreements with other countries. We've been long pursuing those kinds of initiatives. I think we have 6 free trade agreement negotiations going on. There was a recent deal with China back in January, but that is a fairly modest deal. But overall, Canada's priority market is always going to be the U.S., and that's will continue to be the case. And because of that, I think Canada is not going to be entertaining any changes in our review of investments, the Investment Canada Act, all of those provisions. In fact, I think we will be trying increasingly to align ourselves more closely with the U.S. on those issues going forward in order to make sure that we're not seen as a weak spot in the North American market.
I see. So we're not looking to weaken our national security provisions. Is this not a pivot then away from the U.S.?
Well, I think there's an emphasis on developing these other markets, but I think it's clear the U.S. will always remain the priority market for Canada. So there's no pivot away from the U.S. We rely on the U.S. market. The most attention in any kind of efforts will be on preserving access to the U.S. market. I think Canada is simply trying to ensure that it has a broader range of countries that it's trading with going forward. But that's always been an interest of Canada's.
There's been sort of an emphasis on resilience and making sure that there is a less vulnerability to disruptions and changes in markets in Canada. And as Anant mentioned earlier, the Prime Minister has announced recently the creation of a sovereign wealth fund for Canada. The details of that, I think, are to be ironed out. But let's unpack diversification.
Yeah.
When policymakers talk about resilience, like, what are they really referring to in your experience?
Well, it's really about trying to ensure that Canada is on as stable a footing as possible. And that means creating the ability to deal with market shocks, to deal with disruptions by broadening the different markets that Canada is participating in and the Canadian economy is pursuing more broadly. And it's also about reducing reliance on a single market. It's kind of like diversifying your investment portfolio. You want to make sure that you're not exposing yourself to unnecessary risk. So it's about better access to more markets. It's about more security for supply chains. It's about ensuring access to capital to support investment, to fund projects that Canada is pursuing at this point. It's all of those kinds of things, making sure that all of our eggs are not in one basket.
So you mentioned security for supply chains and strategic sectors. And I think that's one of the big changes we've seen. When I first started practicing in this area, national security was really not something that turned up very often. In fact, it was not even part of the legislation.
Yeah.
So turning to that now, the scope of review has clearly expanded in recent years. And I mean, how would you characterize the modern definition of that?
Well, yes, it certainly changed significantly. The targets are a bit different. They're broadened in particular. And I think there's a lot more focus on emerging challenges with non-market economies in particular. And China is certainly figuring prominently in that. And there's a lot more focus on strategic areas, critical minerals, energy, AI, data governance, telecoms, infrastructure. Those kinds of issues are all areas where most governments are focusing on those as strategic interests, which are associated with security concerns. And so there's a real difference both in the target with respect to certain countries, but also a narrowing down of a real concentration on strategic products.
Reviews previously would look really at ownership percentages to see if that triggered a filing, and it was more of a perfunctory kind of analysis. I think a lot of that changed maybe 10 years ago. But now they're going beyond that to look at these kinds of other issues that you're mentioning.
Yeah.
Whereas in the U.S., I think their focus was always more on national security with organizations like the CFIUS framework.
Mm-hmm.
So turning to that, defense concerns, those kinds of things, do you think our approach is actually converging more to the U.S. system in terms of CFIUS and national security reviews?
Yeah, I think it really is, and it has been increasingly aligned with the U.S. approach over time, because I think there's the traditional national security concerns related to defense; those are still there, and Canada understandably takes a slightly different approach to some of these issues than the U.S. does, but the focus and the targets are really quite similar with respect to their objectives. There's shared concerns about security threats. Both countries want to remain open to investment, clearly, but that means allowing those investments only in cases where you can effectively address and manage security concerns. So I think all of those factors, Canada and the U.S. are increasingly aligned on. And Canada has the added incentive that it does not want to be a weak link in terms of the protection of the North American market. We don't want to be in a position where the U.S. is concerned about Canada as a potential source of leakage of some of these security threats. So we want to maintain a strong North American perspective on these security issues.
So let's make this practical. And I pulled up some recent examples of things that have happened in the area. So sometimes, just to support what you've said, transactions have been allowed, for example, if they're coming from a Chinese SOE with mitigants or with limited review, examples such as where a company might have assets in a foreign jurisdiction like Argentina, which is not necessarily Canadian nexus. Or it might be a minority investment in a non-sensitive sector by the Chinese. Some transactions have been blocked pre-closing. Probably the highest example of that was in the construction industry, which was specifically blocked on national security grounds. And some have involved sort of a post-closing divestiture, like, for example, the lithium cases where the Canadian government required Chinese investors to divest these things. And so typical mitigation measures have involved things like governance restrictions, like no board seats, data and information controls, Canadian management requirements, security protocols, and operational constraints within Canada. So given that context, suppose I'm advising a multinational client, and I'm a U.S. practitioner with a Chinese counterparty looking at Canadian transaction in a sensitive sector. Steve, what assumptions should I make at the outset? What were some of the practical guidances I should have?
Well, I think really, I think that any company in that kind of position, any kind of investor in that kind of position should be thinking about trying to get in very early to have conversations with the Canadian regulators, those that are involved in the Investment Canada Act, and the earlier the better, really. Because I think if there's engagement before any kind of formal notification, that gives the opportunity to increase confidence between the investor and the government, opportunity to build a constructive relationship, and it gives the opportunity to address issues that may be of concern before positions start to harden. So really, if you're an investor that's involved in that kind of potential transaction, early conversations are best, because the people that are administering the Investment Canada Act at this point in time are really focused on how can we find a way forward. If there's an investment that has some concerns associated with it, then how do we deal with the concerns rather than just reject the investment overall? That's the new approach. And that's...
And Steve, sort of interrupt you there, but just on that point, you mentioned engagement with politicians, with the government early. And are these things that, in your experience, can be done confidentially? And is it wise to do it all the time, some of the times? What do you think about that?
Well, I would say it's not even so much the politicians. It's more the officials, the bureaucrats that are involved in the Investment Canada Act, because they've been dealing with these kinds of issues for a while, and they've moved away from a process where investments could be prohibited or rejected, to trying to look at investments to see whether there's a possible path forward if certain controls are put in place. And so that kind of dialogue with those officials involved with the Investment Canada Act is really the way to go early on, because they can start to look at the potential transaction, look at the opportunities to introduce constraints that are going to provide some comfort, and find a way to make the investment go forward rather than simply put a stop.
And it's probably worth pointing out as well that when we think of transactions, sometimes we're thinking about just buying an entire company or taking a control position, but I take it even minority positions can raise these kinds of issues.
Absolutely. And that's part of the increasing concern, is that to make sure that it's all covered off, because as I mentioned earlier, Canada does not want to be seen as a weak point in terms of entry into the North American market. And so all of the bases there's a desire to cover all of the bases, and that includes minority positions where that could be an issue if certain sensitive information is being provided.
And just for our listeners who may not be as familiar with Canadian law, the Investment Canada Act, that is the Canadian federal law that governs foreign and direct investment in Canada. Is that correct?
That is exactly correct, yes.
Yeah, it's a great point, Anant. And the fact is that legislation has undergone dramatic change. It used to be one of the few foreign investment laws in the world. Like even in Europe, you would speak with businesses and counsel in Europe, and they just didn't have that kind of thing. And we would mention that, we've got these rules that even for transactions that are just a control acquisition, that's not national security. If it's a direct acquisition, you need to get public benefit or a net benefit assessment done and show that through giving undertakings. Of course, what's happened in the intervening last 10 years is that almost every country has now adopted this kind of legislation, both for national security, but also for things that aren't so national security, even involving dairy or other sensitive sectors that are not in that space. But yes, we're talking about under the Investment Canada framework, which, Steve, I think is fair to say is both a bureaucratic, but ultimately it's a decision by the minister, isn't it?
Ultimately, it is a decision by the minister, but I think that what the officials working within the Investment Canada Act can do is assess where the various levels of risk may be, and they do that through, ideally, a lot of conversations with the interests involved. And that way they can provide advice to the minister that's going to be it's going to be assisted by a lot of detail, a lot of understanding of what all the structure looks like, where the interests are, and then the minister's decision is much easier to take from there.
And it's one of the benefits of getting in early, avoiding media surprises. I'm thinking, for example, if you just announce a transaction and it hits the newspapers poorly, politicians might raise their eyebrows, that you might get entrenched in a negative light. Just speak to that for a moment.
Well, yeah, that's something you clearly want to avoid. And I think that the whole key to that is getting in early, having those conversations with the people that administer the Investment Canada Act, even before the transaction is done, ideally. And then you can start to construct an approach where there's going to be a level of satisfaction with the security concerns. And that means if it does hit the press, there's a lot of answers that are already ready to be delivered. And that's certainly what the minister is looking for, too. Not looking for any kind of surprises or shocks, but something that's been carefully considered with respect to Canadian interests, with respect to North American interests, and making sure that that investment is going to be completely defensible.
And one of the things I mentioned earlier was a mitigant. Now, a mitigant is sort of a remedy, if you will, in a behavioral way to sort of say, yes, you can acquire the company, but you're going to have to do X, Y, and Z to make sure that it complies with the public interest in Canada and national security concerns. Mm-hmm. Historically, that power really wasn't there. You either got sort of a yes or a no. Let's just talk about mitigants for a moment. Do you think today there's more willingness to structure solutions in that way?
Oh, yes, absolutely. And I think that's the direction it's gone, because I think the former model, as you mentioned, usually resulted in either a rejection of the investment or some kind of very onerous action with respect to it. But now, with the greater use of mitigants, you can have a situation where the investment can still take place, which Canada is, of course, interested in. but you can manage it in a way that will provide assurances on the security fronts. And that does involve frequently the use of mitigants. So that can range from restrictions on governance to ensure that the right kinds of interests from a Canadian perspective are involved in the governance decisions. Limitations on access to sensitive information is important because that too can provide some comfort that the sensitive information isn't going to go into the wrong kinds of hands. Issues like Canadian resident management requirements so that there's a Canadian presence on the ground. That provides some assurance as well. There's independent compliance of many of these provisions as well to make sure that there's a comfort there. Data localization requirements to ensure that data that's sensitive is retained in Canada. It doesn't go outside of the country. All of those kinds of issues tend to provide some comfort with respect to that investment going forward if there are assurances on all those fronts.
And it sounds a little bit, Steve, it sounds a little bit like it's getting into the point of being regulation by contract. So is there a risk of that, or maybe we don't care? What are your thoughts on that?
Well, I think there's always a bit of a tension on that front that because the government is looking to provide a number of assurances about the security of any particular project, it could approach some fairly stringent requirements in order to meet that level. But I think really the alternative to that is just to say no to those projects. And I don't think that there's a strong interest in doing that. So better to have a kind of risk-based, tailored approach to make sure that you're allowing the investment if that's possible, but providing the necessary security to address any kind of legitimate concerns in a satisfactory way. And then you're not discouraging the investment, you're just finding a way to manage it.
So maybe a little more flexibility, but a little more predictability at the same time.
That's right. But again, the key is that dialogue between the investors and the companies and the government to ensure that those risks can be addressed in a manner where everyone's comfortable, and then the investment is on a much better track.
Let's widen the lens a little bit. How does this posture affect Canada's broader economic positioning? Obviously, we're in the middle of an area you know better than anybody, which is trade negotiations. Mm-hmm. But in terms of our overall economic positioning vis-a-vis United States-Canada relations, would love your thoughts on that.
Well, yeah, it's all about striking that same kind of balance, making sure that security issues are addressed, but trying to ensure that you're still reinforcing stability, predictability, so that investment is still welcome. And Canada wants to send the message that it's open to investment, but any investor looking to invest in Canada, particularly in strategic products or areas, is going to be disciplined in terms of addressing some of the risks that may be perceived. So Canada is looking for capital, technology, long-term commitments, but it has to ensure that those security issues are addressed, and that's the key to moving forward at this point.
I mean, from a U.S. perspective, it sounds a little bit like the opposite of the introduction, where we talked about Canada's pivoting away from the U.S. towards relationships with China. This sounds a little bit like, in fact, the approach is converging in terms of national security and alignment with the U.S. Would you say that there's alignment there?
I would say there is. I think that Canada has taken a number of steps in recent years, including through changes to the Investment Canada Act and the practices associated with that. You mentioned the divestitures of some companies owned by the Chinese in recent years. All of that is geared towards ensuring that we're aligned with the U.S. as closely as possible. And that's a fundamental Canadian objective. Canada does not want to be seen as um, a weak spot in the North American market, an opportunity for leakage that could occur in terms of the protection overall for the North American market. And Canada has taken steps to move as closely as possible to the U.S. approach to ensure that the North American market, more broadly, is going to be protected.
So you would see the Canadian and U.S. Working on aligning their investment review regimes even more closely going forward.
Yes, absolutely. And when it comes to the review of the USMCA that's currently in the early stages, the U.S. Trade Representative Jameson Greer has indicated that one of his key objectives on a trilateral basis is to align the three countries on tariffs on certain strategic products, on export controls, and most importantly for this conversation, on investment screening. That all three countries are going to take similar approaches to investment screening so that the North American market, again, is well protected. So I think that's really the path forward in terms of preserving the USMCA, that common objective that all three countries can buy into, that we're going to have a common approach in North America to ensuring that these investments are treated similarly.
So there's obviously a lot of rhetoric on all sides going forward and in the recent past about trade issues. I think when you look at the numbers, 90% of our goods are still flowing back and forth trade free. There's obviously a few hot button items. In terms of security, national security, I think what I hear you saying is that there could be greater alignment there between how we generate a sort of North American market that is cooperating on national security and providing for a framework for common investment.
Yeah, no, I think that's really the path forward in terms of securing a strong future for USMCA. If we can align on those issues and have a further reinforcement of the North American market, then that's in the interests of all three countries. And for Canada and Mexico, it draws the U.S. away from a completely U.S.-centric kind of position to looking at the North American market writ large. But the only way the U.S. is going to consider that is if they have assurances that either Canada or Mexico are going to be weak spots in terms of preserving the North American market.
Fascinating and timely. Let's close with sort of some forward-looking guidance to lawyers who are mainly watching this podcast. What should practitioners be doing differently in 2026 and going forward than they were, say, 5 or 10 years ago?
Well, I think the key point is that the process is much more interactive than it used to be. You're not going to simply submit a potential investment or change in ownership to the Investment Canada Act officials and get a yes or a no. You're on a far better path if you go in as early as possible, talk about how the investment is going to be structured, but even more importantly, how any sensitive issues, any security issues are going to be addressed early on. And that can be worked out through ongoing dialogue with the officials in the Investment Canada Act, so that you come to a place where you can still look at the economic opportunity and pursue that, but there are just going to be some guardrails associated with that.
Right. So I feel that national security issues, which perhaps were maybe an afterthought in the past, need to be built right into not just engaging with the government, but right into transaction planning from the outset.
Yes, and that's particularly true for any kind of products that are considered strategic, and that's a growing list these days. But in any of those kinds of investments, you really need to go in early, talk to the officials involved in the Investment Canada Act, set up any kind of mitigants that may be required. So you shouldn't necessarily anticipate a no to those kinds of transactions that could take place. It's more a process of ensuring that there's an avenue forward where you're addressing security concerns in an adequate way so that the economic activity can move forward.
Interesting.
This has been an excellent discussion, Brian and Steve. With so many headlines about Canada pivoting away from the United States, it was really insightful to hear about areas of convergence between the two countries, particularly with respect to national security. And Brian, the discussion of the increasing popularity of mitigants, I found especially interesting given that, at least in the United States, antitrust circles, there's been debate about moving away from behavioral type remedies more towards structural. So all of these points I have found very illuminating. Now, we like to end these episodes with some practical tips that practitioners can take back home with them. So what are the key takeaways here for practitioners?
Well, I think really, given the kind of different environment that we're now facing when it comes to these kinds of investments, really it's all about planning early. Investors should assume that there's going to be a very careful, a very extensive review. And at the same time, where there are economic ambitions, there's going to be some national security discipline. But really, it's all about getting in early, having those conversations, creating that relationship, and then there's often a way that can be found to move forward in almost every case, as long as that discussion is started early and it's a constructive one going forward.
Yeah, and I think you made a great observation about behavioral remedies versus structural remedies, because it's almost like, antitrust likes the structural, and Investment Canada has always been more behavioral, but now a little bit more structural as well, in the sense that sometimes you'll see divestiture of assets or shares and those kinds of things. My key takeaways would really be to a couple of different audiences. Firstly, I think the U.S. investors, it sounded to me, and I think this is our lived experience, Steve, that Canada's still open for business. Expect process, but not prohibition. And in sensitive sectors, there's going to be conditions, mostly behavioral, but usually not blocks from the U.S. For Chinese investors, I think you can assume scrutiny from the outset. It's going to depend a lot on what the sector is and the degree of influence, and that will drive the review risk. And that's true, I think, what we heard today, even for minority stakes. Let me just touch briefly also on Middle East investors, because that's another pivot that we see. That sort of source of funding is generally welcomed, and the Prime Minister has been in the Middle East, making this very clear recently, but it's not exempt. And so the government will look at sovereign links and, again, the sensitive sector. And then I guess the last 2 points I would make, just to pick on what Steve had said, is that deal makers run Canada early and in a parallel way with the U.S. There's no point getting approval in one jurisdiction just to find out that you won't get it in the other. As well, in my experience, and Steve, welcome your thoughts on this, the Canadian regulators like to be at the table as early as possible and not sort of left behind. And I think my last point would be, and this is, right from Steve, who knows this like nobody else, having negotiated the USMCA, which is called different things in different countries, but that's what it's called in the US. And the current tensions, it sounds like there's more noise in the system, but that the pipes are generally still connected. So I think it sounded like we could expect some tariff friction, political rhetoric to affect timing in sectors, but there's such a synergy of efficiencies between the two countries in trade that I think there will be, it sounds like we'll get through that process at the end of the day. That was all I would add, Anant, to the comments that we've had. I hope that's been helpful.
Incredibly so. process, but not prohibition. I love that summation. So thank you, Brian Facey, Steve Verheul, for a discussion that I think is going to be incredibly helpful for anyone with multinational clients considering investment in Canada. To our listeners, be sure to subscribe on your podcast platform of choice and follow us on YouTube. And we'll see you next time. Trust and Trade.